welcome to the first episode of Legal Wrangle on Goods and Service Tax, GST. The most talked about indirect tax reform was implemented on 1st July and it has unfortunately run into litigation. Of course, some of the grounds are procedural in nature and some are about the wires of the law and the legislative competence of the Parliament. The very first decision of the Supreme Court of India has also come. On a very rare occasion, the Apex Court entertains any petition against an interim stay order granted by the High Court, but in this case, the Supreme Court did find merit in the arguments of the Attorney General and granted stay of the High Court interim order. And the case is?
This case relates to the levy of Clean Energy Cess under the Finance Act 2010. For the purpose of providing compensation to state for loss of revenue arising out of the GST implementation, the GST Compensation Cess Act and rules thereunder prescribe methods for manners to notify this levy. And thus, the cess at the rate of Rs 400 per ton of coal has been reintroduced.
The taxpayer challenged the constitutional validity of the GST Compensation Cess Act 2017 and the Delhi High Court saw prima facie merit in the contention of the taxpayer that 101st Constitutional Amendment Act does not enable Parliament to levy any cess, which stood abolished in terms of the third schedule of the Taxation Laws Amendment Act 2017. And granted relief subject to certain conditions that as far as the additional levy of the stocks of the coal on which the taxpayer had already paid the Clean Energy Cess in terms of Finance Act 2010, the taxpayer should not be subject to another bout of cess. However, on stocks of the coal on which no Clean Energy Cess under the Finance Act 2010 was paid, any payment made in terms of GST Compensation Cess Act would be subject to the result of petition.
But the revenue did not grant any relief to the taxpayer and preferred to file SLP. And with the Apex Court getting convinced by the submission of the Revenues Council, a stay of the High Court order has been granted. Let me go to TIOL founder-editor Mr. Shailendra Kumar for his prima facie observation on this case and the rising trend of litigation against the GST laws.
As per my understanding and my experience, it's very rare that there is an interim order from the High Court and the Supreme Court of India has intervened. But I guess in this case, the revenue insisted probably only on one particular ground, that there is a settled law. There are several constitution bench orders where competence of the Parliament is well established to make any kind of fiscal law. And I guess in that context only, when the law passed by the Parliament with respect to compensation cess is there in place, and the government and after the GST recommendation, GST Council's recommendation, the cess has been notified again on coal. I guess on that ground only, because this cess is different from the cess which was imposed under the Finance Act 2010. So, Clean Energy Cess, which was earlier notified under Finance Act 2010, is gone, and under this compensation cess it has been imposed. So, in that context only, I personally feel that what Supreme Court of India has done is probably it was sensitized by the Union of India, by the Attorney General, that this particular cess is to compensate the states, since the states and the centre, and all of us know that Union of India, as per article, as per the list 1 and entry 97, it has indefinite power to levy any kind of taxes, any kind of fee, any kind of cess. And in this particular case, I find that it's not only Union of India, but also the states who are part of the GST Council, and that is how probably the Supreme Court of India decided in its wisdom to intervene and stayed the interim stay order of the Delhi High Court.
Thank you, sir, for your valuable insight. We will keep track of this case and bring to you the latest after the final judgment is delivered. Let's move on to the next case.
In this case, the assessees were the auction purchasers of scrap. The Controller of Stores and Purchase, KSRTC, had issued a tender notice for e-auction of the old and junk buses. Before the court, the assessee raised an objection stating that in the said notice inviting tenders (NIT) from the intending purchasers of the scrap buses, the rates of GST was given in column number 4 of the annexure A notice as applicable. Before the bench, the assessees submitted that the rate of GST tax applicable on the scrap buses, which cannot be piled on the road as normal buses and they can be put to auction only after being certified by the concerned RTO authorities as scrapped, cannot attract 28% rate of GST. It was also observed by the court that whether the correct rate was 18% GST as claimed by the assessees under the entries of Schedule 3 or 28 cannot be clarified either by the KSRTC or the Commercial Tax Department. It was for the assessees to participate in the tender process as per the terms indicated therein and not to so participate.
The court does not have any definite information about the actual constitution and manning of the advance ruling authority by the state, but that cannot be a ground at all to invoke the writ jurisdiction prematurely.
Considering all the submissions, the court was satisfied that such initial tender process initiated by KSRTC, the petitions filed by the assessees were premature and misconceived and does not require any interface at this stage. The GST rate as indicated in the e-tender notice does not give the fixed rate of GST at 28% as submitted by the assessees. It only stipulates the rate of GST as applicable. Now let us go to our next case.
In this case, the assessee was a partnership firm engaged in the business of construction and development of entertainment facilities, including multiple theatres in the district of Saharanpur. As per a scheme under the UP Entertainment Betting Act 1979, the entertainment tax officer permitted the assessee firm to retain such amount of entertainment tax so as to enable it to recover the cost of construction of multiplex.
With the introduction of CGST and UP GST Act 2017, the earlier act was repealed but with the saving clause. The assessee claimed the right to collect entertainment tax as in the past up to 31st March 2020 as no such notification repealing or revoking the tax exemption was issued.
The High Court directed the Council for the Revenue to file counter affidavits and asked them to inform if the scheme granted tax benefit to the assessee was still in effect or stood revoked either automatically or by fresh notification.
In this case, the attempt of the assessee company to make payment of IGST partially from CGST credit and partially from SGST credit was frustrated when the electronic credit ledger available at the portal www.gst.gov.in showed a pop-up error message which stated that offset the CGST credit completely before cross-utilization of SGST credit against IGST tax liability. And also, there was no such rule prescribed in terms of Section 49 of the CGST Act.
It was also pointed out that under Section 146 of the CGST Act, the mandate of the Common Goods and Service Tax electronic portal was to facilitate the registration, payment of tax, furnishing of its return. The assessee also submitted that such portal could not be programmed so as to delay the utilization of CGST and SGST credit in a manner not envisaged under Section 49, Subclause 5 of the Act or the rules made thereunder Section 49, Subclause 4 of the Act. Considering all the material facts, the bench granted a stipulated time frame to the Council appearing for the GST network to obtain all the relevant instructions. The Petitioner Association was aggrieved by the glitches in the Goods and Services Tax Network website and the petitioner claimed that the website was dysfunctional. The petitioner submitted that the GSTN website needed corrections and updates to meet the requirement of the users.
Upon considering the submissions of the practitioner, the Rajasthan High Court suggested certain measures to mitigate the grievances of the users of GSTN website. Firstly, the court suggested that any user attempting to log on to the website, and if website does not respond, such assessee or chartered accountant or tax practitioner could immediately drop an email to the district information officer informing about the same. The address of each district head was to be provided, and also the problem pointed out was to be resolved expeditiously.
The court also directed that the revenue take no coercive action such as imposition of penalty, late fees, interest or prosecution against any of the client of the petitioner member who are referred in the petition and are informing by email. In such way, the court gave a measure of protection to the petitioner members and their clients.
The subject matter of this petition was an email to the Additional Commissioner Policy of GNCT of Delhi by Vice President Services of Goods and Services Tax Network GSTN, where certain issue raised by the former had been addressed.
The first query raised was by what time the facility of filing advance ruling application would be made available on GST portal. In reply, the date was provided as by 15 January 2018 tentatively. The second query was that where it was decided to accept the form manually, whether there was any mechanism available on the GSTN portal whereby applicants, including an unregistered applicants, could make payment of prescribed fee of Rs 5,000.
In reply to such queries, it was stated that for the intervening period, a functionality is being developed to dispose of the advance ruling application manually with the facility to deposit prescribed fee under the law through GST portal for all applicants, including unregistered persons. This facility will be available with effect from 20th October 2017 on the GST portal.
The court opined that it was clear from the above reason that the web portal for uploading an application seeking an advance ruling would not be ready till the 15th of January 2018. As an alternative, the GSTN decided to accept all the application, including application from unregistered persons, manually with the facility to deposit the prescribed fee through the GST portal. However, it was unclear under the authority of law the GSTN had decided to postpone the availability of such alternative system when the provision of law are already in the force. The court held that the respondent had failed to answer this question, hence the court directed that notice be served to the respondents.
With all these cases, we thank you for watching this episode of Legal Wrangle on GST. Please stay tuned to TIOL Tube for more videos on subjects pertaining to direct, indirect, corporate law and international taxation. Please feel free to share your feedback with us at editor@tiol.in. Thank you and have a good day.